Hello, and welcome back to the Garrulous Gavel. I'm your host, John Tico, and in this episode, I talk with Ann Champion. She goes by Annie, and she is a litigator and a partner with the international law firm of Gibson Dunn and Crutcher. Our main topic will be legal protections for the press and publishers, including anti-SLAPP statutes and the famous First Amendment case of New York Times versus Sullivan. In recent years, these protections have come under attack from those, including two current Supreme Court justices, who think the press doesn't need or deserve special protections from libel lawsuits. We'll talk to Annie about her representation of Mary Trump in two different lawsuits relating to her book about the Trump family. And we'll also discuss a libel case that's been in the news lately, brought by Sarah Palin against the New York Times. Then we'll get garrulous with Annie about something that's a little more personal to her. 25 years ago, a high school friend of hers, Laura Van Wyhe, was found dead by the side of a road, apparently the victim of foul play. The case has remained unsolved all these years, and Annie has made it a personal mission to uncover new leads and to try to solve this case. The intertwined stories of Laura's death and Annie's search for the truth have recently been the subject of a really interesting podcast called Bonaparte. And we'll talk to Annie about the making of that podcast and about her continued hunt for clues. I hope you find this conversation interesting. Welcome to the Garrulous Gavel. I'm John Tico, and my guest today is Annie Champion. Hello, Annie. How are you today?
I'm great.
Annie is coming to us from New York City, and I will say for the record that today's date is February 15, 2022, although we'll release this a little later than that. But the significance of that date is that as we are recording this, we are waiting for the jury verdict in the defamation case that Sarah Palin brought against the New York Times, which is taking place in federal court up in New York City, where Annie is. And our topic today is going to be legal protections for the press in the United States. We're going to be talking to Annie, who has represented a number of media entities and other parties in litigation over those legal protections. And we're going to be talking a little bit about the federal constitutional protections for the press that arise from the famous New York Times versus Sullivan case and some of the controversies that have surrounded that case in recent years. So it's a very timely interview, and this should be a fun discussion. We're also going to talk towards the end of the interview about Annie's other podcasting ventures. She is the, I guess I would say, featured character, if you will, in a really excellent podcast called Bonaparte, and which I highly recommend to everybody. And we'll talk about what that podcast is and Annie's involvement in it a little later in the interview. So stick around for that. But we will start out, as we always do, by learning a little bit about our guest, a little bit about their life and how they came into the law. And so I will start by asking Annie, where are you from?
I am from Iowa.
Okay. And what part of Iowa?
I grew up in a college town, Iowa City. So suffice it to say that I didn't watch the Super Bowl until I was in my mid-20s, because in Iowa, it's all about Big Ten football.
And who did you root for growing up?
The Hawkeyes.
Okay. And did you just lived in one town your whole life growing up?
Yep.
And sort of how big a town is Iowa City?
Well, it's one of the smaller college towns. So I think with the university population, it's about 100,000.
Okay. And so that is is that where sort of like the main university campus is?
Yes. University of Iowa.
And were you connected to the university in some way growing up?
Not really. My dad is a doctor. He was in private practice. He went to medical school there. He did teach residents, but that's about my only direct connection to the university. I went to undergraduate school there as well.
Oh, okay. So you stayed there after high school through college?
Yep.
And what did you study when you were in college?
I was actually a physics major, believe it or not.
Well, I believe it. Why do you say it that way? Why do
Just
you say believe it or not?
There's not too many of us, first of all. You hardly ever meet another physics major. And I think it's also somewhat unusual for a lawyer. There's not a lot of physics major lawyers.
That's true. I mean, I started out as a physics major in college,
Oh,
but
did you?
but I did not graduate as a physics major. I graduated as a history major, something more traditional for law. But I still love physics and science.
Yeah.
So that's great. And well, I mean, I actually think I'd be interested to know your view of this. But I tend to think that people who have some science or mathematical background actually do pretty well as lawyers because there is a sort of a rigor to logical thinking that you learn from those fields that actually can serve you quite well, particularly if you're a litigator.
I agree with that, actually. I think that you learn rule-based thinking. And I think if you have the writing skills that it takes to be a lawyer and you have the discipline, and by discipline, I don't mean work discipline, although there's that too, but I mean the thinking discipline, the ability to think within a set of rules. I think that's what you need to be a lawyer.
Yeah, that's right. And so, hey, listeners, if you're a science major or an engineer or a mathematician, you should go to law school. So how did you get from being a physics major as an undergrad to being a lawyer? Where was the inflection point or the change in your thinking?
Well, so by the time I graduated with my undergraduate degree, I kind of sensed that I was probably not going to continue with science because I never liked laboratory work. And so I really liked the math and the thinking, but I was like, that doesn't seem like a real job. I mean, actually, I probably could have found a home that would have made sense for me as a physicist, but I couldn't really think of what it was at that stage of my life. So I was kind of like assumed I would go to grad school at some point, but I just didn't really know what for yet. So I moved out to New York City and my first job was working for a physicist who is a consultant. And I didn't really, it was okay, but I didn't really like that job either. I sort of didn't like the science once removed type of thing either. Like he was actually would sometimes serve as an expert witness, so I did a little bit of litigation, I guess, in that role. And then I had a couple of different jobs and I worked at the Audubon Society for a couple of years and really liked that. And then I thought, well, I should probably go to grad school and get like a real career. So I had actually done a lot of foreign languages as an undergrad. And I spent a lot of my time after I finished my undergraduate degree traveling around, learning languages. So I thought, well, maybe I'll do comp lit. And actually, I always loved literature. I was always a book person. And I could have easily majored in that as an undergrad. But to be honest, it seemed too easy or too obvious. It just didn't seem very challenging at that time. But I had taken a lot of foreign languages as an undergrad. Basically my entire transcript is science, math, and foreign languages when I was an undergrad, except for the few distribution requirements that I had to do, right? So I did a master's in comp lit, and I realized that I really did not like writing academic papers, which, obviously was not compatible with getting a PhD. And then I actually was temping at a law firm when I was writing my master's thesis. And I was like, this is what I should do. This is perfect for me. So that is literally how I became a lawyer.
Were you living in New York through that whole thing? And the master's was at a school in New York, and you were working
Exactly.
through that. Mm-hmm.
Yeah, at the CUNY Graduate Center.
Why did you decide to move to New York City?
I literally am one of those people that woke up one morning and said, I want to move to New York City. And I did. I mean, it's literally not any more complicated than that. Mm-hmm. I did not have a job or a penny in my pocket when I moved here. And it all worked out, but there was really no reason for it except that I wanted to live here.
Yeah, well, so just out of curiosity, sort of why do you think that was? Were you just sort of drawn to this sort of other extreme? You had grown up someplace small and wanted to go to the opposite extreme, or was there something else that drew you to New York City?
Well, I had visited here and really liked it. but I definitely think there's something to what you're saying. I mean, I think I had traveled a lot. I wanted to be, in a more cosmopolitan environment, a more diverse environment. And New York City appealed to me. I also think that even though I'm from Iowa, I strangely have always felt like I really fit in here, which is, I think New York has that, it has that feeling for a lot of people though. Like, I don't think I'm unique in that regard at all. I think it's such a welcoming place. I know people like to think of it as this big bustling city, but in a way it's not, because it's just so tolerant it's such a tolerant environment. It's such so tolerant of differences and different kinds of people. And I think I always felt at home here. I also think like my natural sort of speed and conversational style fits in very well here. Whenever I go somewhere else, I'm always, like New Yorkers, like the whole way that we engage with each other and communicate with each other, there's always a lot of humor involved. Like everybody has a sense of humor here. And I think that's something that always has resonated with me as well. And whenever I go other places, I always miss that.
Yeah, you just wanted to go someplace where you could talk faster. I get it.
Exactly. Yeah.
So, all right. So you do your master's in comparative literature, and then it just, so you wake up one morning and you think, okay, the next logical thing is law school.
Yeah, I mean, I was working at a law firm, like a pretty small firm here in New York City that's still around in one form or another. I'm still in touch with some of those lawyers. And it was just like a general practice firm. They did a little bit of litigation, a little bit of trust and estates. And it just felt like a great match for me, because I didn't like the isolated feeling of academia. I think that's why I didn't want to work in a laboratory either, but I didn't find that aspect of it very different in literature, right? You're still basically generating work product that, it's got an academic function. There's not very many people who are going to want to read it. It doesn't really have a purpose other than advancing a field of study, which, I have a lot of friends who are academics, and you really have to be interested in that aspect of it if you want to pursue that as a career, right? And I just felt like that's not really me. Like I want something that's more practical. I missed also the problem solving of science. I missed the problem solving. So I got into a law firm and I was like, okay, this is intellectual. It's problem solving. It's out in the real world. Like, this is what I should be doing. This is perfect for me. And having grown up in an academic town, I was exposed to so few professions as a young person. I think if I'd been exposed to the legal world at an earlier age, I would have understood earlier that it was a great fit for me. But I just really wasn't. I had a couple friends' parents who were lawyers, but anybody out there who grew up in a college town knows what I'm talking about.
Right.
Those towns are so dominated by the college.
Yeah, that's interesting. That was a little bit of my experience too. I mean, I grew up in Stony Brook, New York, which is also a college town, and didn't have lawyers in my family, didn't know lawyers. And it really wasn't until I actually got to law school and maybe had my first real summer job that I started to kind of figure out what the profession really was. But okay, so you decide to go to law school, and you ended up at George Washington Law School in Washington, D.C., right?
Yep.
And any particular reason why you ended up at that school, or you just applied to a bunch of places and that's where you got in, or kind of?
I got a huge scholarship from them.
Yeah.
So, and especially for me, having not much, like no lawyers in my family, having really no idea what I was getting myself into, that was comforting to me, because as you know, law school is extremely expensive.
Yeah.
And I felt like, how am I ever going to pay back this money? When you're in an academic field, you get teaching assistantships, like you kind of pay your way through. But law school's not like that. And I was terrified about taking on that much debt, So I was very grateful for the scholarship.
Yeah. And that's where I met you for the first time.
Correct.
Like 20 years,
yeah.
20 years ago, probably something like that. I happened to be teaching as an adjunct at GW Law School, and you were in my first class, sort of a legal writing class, and And what I mean, I remember a lot of the students I had. I only did it for 2 years, and I think we had 12 students each year. So I probably had 24 students total over 2 years, and I remember quite a few of them, and have stayed in touch with a number of them over the years. But I will just say for the record that it was entirely obvious to me that you were going to be an extremely good lawyer, like right from the outset. Somehow, maybe it was your grad school experience, or whatever, but you were really an excellent writer. Right from the beginning. So, and so you went to school at GW, and then you sort of took a fairly traditional route out of law school into a large law firm. Tell me a little bit about kind of your thinking and your decision making about jobs coming out of law school.
Yeah, again, this is an area where I think it's really helpful to have people in your life who are lawyers who understand a little bit about the market. I really didn't have that. And in fact, you're the person who told me to apply to Gibson Dunn. So thank you for that. But I really didn't know what I was doing, quite honestly. And so a lot of it was just feel. And I kind of knew, I strongly suspected that I would probably want to end up back in New York City, but I wasn't sure because, as you know, DC really is a fun place to be a lawyer. There's all these government jobs that don't exist anywhere else. There's a bunch of think tank jobs. But I kind of knew, like, I was dating somebody here in New York and, that I ended up marrying. So I kind of thought I'm probably going to end up back in New York. So I wanted to work somewhere as my 2L summer where I could have that possibility of going back up to New York. And because I was getting good grades and all that, I was kind of being pushed into the OCI and clerkship routes. And again, that all turned out for the best. But so I really didn't know what I was doing. I kind of tried to ask people for advice about which firm should I be applying to, what should I be looking at. I also really didn't know what area of law I wanted to practice in. I think I knew pretty much that it was going to be litigation because of the research and writing and problem solving. I mean, all of that made sense, right? There was no real question that I would be a litigator. But I really didn't know what area I wanted to practice in. So I also wanted to go somewhere that had a good variety of practices in litigation, right? And that had a strong litigation group. But also, because of the New York thing, I also kind of knew that I didn't want to, I just had a sense like, I don't really just want to litigate for banks or something, right? So I wanted like a firm that had a broader litigation practice in that. And that's a big reason why I ended up at Gibson Dunn, because it's a national firm, as you know, LA based. And because of that, the litigation practice is just broader here than it is at a lot of New York Wall Street firms, which there's a lot of great ones, but we really do have a pretty special, varied litigation group here. So that's how I ended up at Gibson. And I really like the people, which I always tell people that's important because we work hard,
Yeah, absolutely. And so you were a summer associate there, your second summer?
Yeah, and I did like half my summer in DC and half in New York, which completely different experiences, actually.
Oh, well, tell me about that. Like, what was the difference?
Well, so my 2L summer would have been 2004, I guess. And at that time, Gibson Dunn DC was they had just won Bush v. Gore, right? So they're in the throes of kind of the Bush conservative era. So a lot of conservative lawyers, many of whom I still work for to this day, but it was very like, kind of a conservative hothouse at that time. And then whereas the New York office, which had a much more of an upstart feel, it was still a relatively new office. It was the newest U.S. office of the firm at that time, I believe. Maybe not newer than like Denver, but pretty new, right? And so it had kind of an upstart feel. It was still pretty small. We've tripled in size. This office has tripled in size since then. So it just had a much more kind of upstart feel. And it's in New York. So, it reflected New York culture, which is much more, liberal, like work hard, play hard kind of culture up here as compared to DC, right?
Yeah. Yeah. No, you're right. You're right about the politics of the DC office. That was true when I was there as well. And so you go there as a summer associate, presumably they wine and dine you to your heart's content. and offer you a job at the end of the summer. And did you go directly back to Gibson Dunn after law school?
I clerked for a year on the Third Circuit, and then I came to Gibson Dunn.
Okay. Who did you clerk for in the Third Circuit?
Judge Rosen.
And maybe say a little bit about what that experience was like for people who maybe don't know what it's like to be a law clerk for an appellate judge.
I think that it's a great experience. I think it teaches you to look at cases the way that a judge would, which is to be fair and to not, judges. I think lawyers oftentimes we get so on our client's side and on our client's team that we forget to look at the bad facts the way that a court has to, or the way that any impartial trier has to look at them. And I think clerking really teaches you need to resist that impulse as a lawyer. You've got to deal with the bad facts. You need to have a coherent legal strategy from the outset of your case. I mean, as you know, having worked for some of the great appellate lawyers at Gibson Dunn, if you have a coherent legal strategy that, that preserves your issues for appeal, you can lose a case and then win it on appeal, just as long as your strategy was right. Right. And so you have to know which issues to preserve and how to preserve them and how to litigate them in a way where you can win them on appeal. So I think it teaches you that too, which is how to look at your case from a legally strategic, in a legally strategic manner.
And just what was the day-to-day of being a law clerk?
Well, to be honest,
what are you actually doing? What does it mean to be a law clerk?
Well, you are, you're attending arguments when they happen, which for appellate judges is, it depends how many sittings they have, but usually it'll be a few days a month, right, where you actually go hear argument. The rest of the time you are writing bench memos and you're conferencing with your judge about what you think about a case. So you're writing a memo for the judge about the case, which way you think the decision should go. Your judge may or may not agree with you, but you having somebody else help them think through that process is very helpful to them, right? And every judge is, of course, a little bit different in what they want from their clerks, but I think most appellate clerks pretty much operate that way. And then once there's a decision made, then you're helping the judge write opinions if the judge is assigned to it. There are also some additional duties that can come along with an appellate clerkship, like you might be the motions judge for a little while, or, you get on these, I forget exactly how it works. It's been a while, but you might get a spate of like Social Security cases or immigration cases that have to be dealt with in a more expedited manner. So, there's some additional things that happen there too. Mm-hmm. But one thing I will say about it too is that it's amazing how much of a federal appellate court's docket is immigration and Social Security. And those aren't the cases that you hear about, but that's a ton of what appellate judges do.
Yeah, that's true in the district court level too, in the trial courts in the federal system where I clerked. Certainly the cases that you read about in the press, very large, complicated, high-profile, contentious cases. But the day-to-day work of the judiciary often involves much more mundane, routine kind of cases. A typical federal judge has hundreds, or maybe these days, maybe even thousands of cases on their docket. And the vast majority of those are just, disputes that have to get resolved by somebody. And it's the judge's job to resolve them.
Criminal too, of course, right?
Yeah,
habeas,
right.
Lots of habeas.
Right. Lots of, prisoner cases is a big part of the docket. So yeah, there's just lots of cases that the federal judges have to handle that never sort of get any public attention at all, but that are a big part of the day-to-day work. And that's true at the appellate level too. Yeah. And so after your appellate clerkship, you went directly to the New York office of Gibson Dunn?
I did, yeah.
And you've been there nonstop since then, right?
I have, yeah. I never expected that to happen either.
Yeah, and it's not sort of the normal path anymore. I think most lawyers that I talk to bounce around quite a bit, move from job to job, which is one of the nice things about being a lawyer sometimes, that you have a lot of opportunities to change jobs periodically. But you've been at one law firm now for 15 plus years, right?
Yeah.
Yeah. And you survived being an associate, became a partner of the firm, which is not an easy thing to do at a large law firm. So you sort of experienced big law firm life at both the associate and the partner level. I mean, we won't spend time talking about everything you've done for 15 years because we want to get to the juicy stuff we want to talk about. But just, give me like a thumbnail sketch of kind of what that experience has been like for you, being inside one of these huge international law firms for so many years.
Well, I mean, I think the reason I've stayed is because the work has always been interesting. And the nice thing about this firm is that I've been able to try whatever I wanted. And I did, I really did try everything. And then it's funny, I always tell people if I looked at my resume, if I looked at a resume like mine, if I were recruiting somebody, I could sort of predict where I would have ended up. But as a lawyer, I didn't know that as a junior lawyer. So I was very lucky to come somewhere that let me try everything. And I ended up, again, as I told you, I took a lot of foreign languages. I traveled a lot. So now I really practice in a space where I get to use all of those skills. I do a lot of international work. Lately, I've even started doing some international arbitration where we're suing mostly sovereigns. And that work is really fun and always involves investigations in foreign countries and stuff like that. And I think where I really cut my teeth on a lot of that stuff was a big case for Chevron, which has gotten more press coverage than, almost any other legal dispute in history. And so I won't go into details on that, but suffice it to say that it was a really fun case where we really got to try everything and do everything. We ended up bringing a civil RICO case. That's still a big part of my practice now. People always want to use civil RICO. 1782, which is a discovery statute that allows you to take discovery in the U.S. for foreign proceedings. We did a lot of that. We kind of wrote the casebook on that because it had not been used very much before we started using it for that case. And, there's still a little bit of that going on. That did end up with me having to be a witness in a criminal case, which was not really very much fun at all. But the lawyer that we sued for civil RICO ended up getting charged with criminal contempt in a later phase of the case. And I actually had to testify at his trial, which again was not, it made me have a lot more sympathy for the experience of being a witness and how stressful it is. I will tell you that. It's very stressful.
Yeah, absolutely. Well, that is a fascinating case, and we could do a whole nother episode just
Yes.
talking about that case. But at least part of your practice, maybe in recent years, has been doing some media and First Amendment work. So before we launch into the discussion of some of these cases, maybe say a word or two about that part of your practice.
Yeah, so that actually goes back to law school. I helped Professor Dinas at GW edit a book called News Gathering in the Law, which is still being published. He's no longer a co-author because he's retired since then. But that is all about journalists' access to documents, spaces as reporters, right? So it's about press access, at least the parts of the book that I worked on. And that was a lot of fun. I really liked that. And I took a First Amendment seminar at GW with Professor Barron. I also really liked that. So I always tried to do as much of that as I could here. And at the time that I started, we did have actually a dedicated media law partner. And by media law, I really mean First Amendment, right? Because media law, we also kind of fold in entertainment with that. But we had a media law partner. So I always tried to do a little bit of that. And every once in a while, we would get to do an access case or something like that, right? So I always had a toe in that. And then Ted Boutros, a partner in our LA office, has also always done a lot of that work. And so I really picked up when Trump was elected president because whether through inexperience or otherwise, they did a lot of things that governments hadn't even tried to do for a few decades, including revoking Jim Acosta's press pass, his White House press pass early on in the administration. So we represented Jim Acosta and CNN in that case to get his press pass back. That was just a 7-day whirlwind where we won the preliminary injunction. And then the case, we were able to settle it after that. And then we did something similar for Brian Karem, a freelance journalist at that time who was working for Playboy as their White House correspondent. So we represented him in a similar case where they revoked his press pass or suspended it. And then, there's been other First Amendment related work. We represented Mary Trump in a case involving the publication of her book, Too Much and Never Enough. And that was just classic prior restraint case. And now we're representing her in a case where the president has tried to sue her again over that book and also over her role as a source for the New York Times when they published their big expose about Trump's finances. And so she was sued over her role in that.
All right. So maybe that's a good entree into our substantive topic for the day. So we want to talk a little bit with Annie about what the legal protections are in the United States that are sort of specific to what we call the press. And maybe the Mary Trump case is a good entree into that because I know that some of the defenses that are being raised in that case are defenses that are typically raised in media cases, although from what I understand, that is not a defamation case, right?
No, it is not. So actually with her book case as well, this case centers around or purportedly centers around a confidentiality clause in a settlement agreement that Mary and many other family members and related organizations entered into over 20 years ago after Mary and her brother objected to the wills of the grandparents. So this is Frederick Trump Sr., the president's father, and his mother, Mary's grandparents, right? And her and her brother had objected to the wills, and they had also filed separate litigation over the termination of health benefits, right? So Mary and her brother are the children of Fred Jr., the president's older brother who predeceased his parents, right? He died rather young of a heart condition. And so because of that, Mary and her brother had inherited certain interests directly from their father. And so this settlement agreement settled all of these family disputes and resulted in Mary being effectively bought out of the family business, right? They had a confidentiality clause that says, in order to, facilitate the settlement of these disputes, the parties agree to keep certain things confidential, right? So it's this confidentiality clause that is supposed to facilitate settlement. The financial terms of the settlement were performed 2 decades ago, right? And then this settlement agreement suddenly resurges when Robert Trump, the president's brother, sues to stop publication of Mary's book in the summer of 2020. So right before the upcoming election. And that's when this thing resurfaces. And so, NDAs, confidentiality clauses, are generally enforceable, right? But the question was, did this one apply at all? And even if it did apply, could it apply in a way that was consistent with the First Amendment?
Right. And so, did you represent Mary Trump in that case?
We did, yeah.
I mean, can you say anything about how you became her lawyer or how Gibson Dunn became her lawyer?
I can actually, because it's pretty much public now. We actually started working with her when she was a source for the Times, because the concern at that time was that that the family would realize that she was a source and try to, do something, come after her on some kind of legal grounds at that time. That actually didn't happen. But because of that, we had been in contact with her and kind of knew the whole background. She was interested in writing a book. I kind of helped her, just using my contacts, helped her navigate the world of book agents and things like that here in New York. And so I had some, contact with the whole process of her writing and getting the book published. So we were in touch with her the whole time, and we were familiar with the legal issues by the time the book case was filed. So that's actually how it happened. We had actually been working with her for a couple of years before the book came out.
And the case that was brought by Robert Trump, was the intent of that case to sort of try to get an injunction against the publication of the book?
It was, yeah. So it was brought against Mary as well as the publisher.
Yeah, so that kind of brings First Amendment concerns sort of front and center, right?
Yeah, so They've actually, because the settlement agreement was out of surrogate's court, which is the probate court here in New York, right? So the settlement agreement comes out of surrogate's court in Queens County, which is where the grandparents' wills were probated, right? So he actually first tried to file in surrogate's court, Robert Trump, ostensibly. And there's a whole backstory there, which we can get to. So Robert Trump first tries to file this case in surrogate's court, but the surrogate's court is a court of limited jurisdiction. And even though this settlement agreement settled cases in surrogate's court and was entered by the surrogate's court, it also actually settled cases in regular federal court. But because it was entered in surrogate's court, he first tried to file there, and the surrogate's court said, I don't have jurisdiction over this, right? We don't hear contract disputes in surrogate's court, even if they relate to a surrogate court matter, right? So then he has to refile. He refiles in Dutchess County, which is north of New York City. Robert has a home up there. And it's funny because Mary, because, she is a Trump, she was aware at that time that Robert had been hospitalized. He was having severe health problems at that time. So, we always had our thoughts about who really was in charge here. And I think the president even came out and made a few statements about the book around this time, right? So this case is ostensibly filed by Robert Trump. And he seeks to stop publication and distribution of Mary's book, which is being printed, as this is going on, is on the verge of being distributed and sold. So it's classic prior restraint. Like, I don't think a U.S. court has ever, it's been at least a century since there was any prior restraint. So, U.S. courts just do not engage in what is known as prior restraints, which is U.S. courts will not enjoin speech. They will not enjoin publications of books. And if there's going to be an issue with that, it will have to be addressed as a damages case or whatever after the fact, right? But it is a little bit different, at least when you have an agreement, right?
Yeah. And just to put that point into plain English for people who are listening, right? So what Annie is saying here is that under the First Amendment to the U.S. Constitution, federal courts generally will not issue an order stopping speech. They will always allow the speech to occur, and that's what we mean by no prior restraints. That they will not try to restrain somebody from making a public statement or publishing, in this case, a book. That doesn't mean that the statement or the publication is cost-free to that person. There could be other consequences from making the statements. It could be a breach of contract. It could be libel. So it could expose the publisher to other types of claims. But the First Amendment basically tells the courts, you have to let the speech occur first, and then you deal with the consequences afterwards. Is that sort of a fair summary?
Exactly. Although, again, it's interesting because this was taking place right around the same time as the litigation over John Bolton's book, which you'll recall the issue with John Bolton's book was that certain government employees have to engage in a pre-publication review when they write a book that pertains to their work at the government, right? And Bolton was under such a requirement. And the allegation was that he had not properly engaged in that pre-publication review process. And even there, the court did not enter the prior restraint, although I think it came as close as I've ever seen a case come, at least in recent years. And I think if that book had not been, it had actually already been distributed to members of the press. I think it's possible that there would have been some kind of restraint on the distribution of that book. And Mary's situation, because they were asserting that this contract applied, and again, we argued that it didn't apply at all, and the judge ended up agreeing with us about that. But you can contract away your First Amendment right. So if John Tico entered into a contract that said, I will not write a book about my time as a legal research and writing professor at GW, theoretically that contract could be used to stop publication of your book about being a legal research and writing teacher, right? But so they had at least a sliver of an argument because they're trying to say that this confidentiality clause applied. So it wasn't quite the same, as some prior restraint cases where they really have no hope, right? Usually you might see it like, have you seen these recent news stories about like these billionaires' tax info being published, right? and being leaked online. Like that is a classic prior restraint, right? There's no way you're going to be able to stop that. But if you at least have a contract or something, you at least have an argument.
Yeah. So, I mean, that's interesting. And I don't know if you know the answer to this, but in sort of a more traditional NDA situation, a non-disclosure agreement. I mean, let's say you and I have a lawsuit. We settle the lawsuit. I pay you some money, and there's a non-disclosure agreement in the lawsuit, and then you just decide you want to breach that agreement, and you want to make a public statement about something that's covered by it. I mean, I would think that under those circumstances, even then, the court would not issue a prior restraint. They might say, well, you're going to be in breach of the contract, so you should think about whether to do that, because you could get sued for damages or whatever. But I mean, are there situations where courts have issued prior restraints in the NDA context?
I don't know if there are any relating to publication of books. It's a good question. There are certainly cases where courts have enforced NDAs, but I'm not sure that there's one that really looks like a prior restraint, right? It's usually what you're saying. It's an after the fact damages case, right? But, you know, the other issue is it depends to some degree on the wording of the NDA. Does it have, did you agree to the entry of injunctive relief, right? Some NDAs do that. They say you agree that any violation of this constitutes irreparable harm, and you agree to, you know, that an injunction could be entered to stop the conduct.
Right. Now, there's an easy way around that, right, though? Right, which is that I can hand that settlement agreement and whatever I want to say to a reporter, right? And now, if the reporter wants to report that substance, the substance of whatever's covered by the NDA, right, you would not have that argument as it relates to the reporter, right?
That's correct. And so, in fact, that dichotomy came out in this case because they had arguments against Mary that they did not have against the publisher, right? They had no contract argument against the publisher. And you'll see in this new Mary Trump case, they've asserted tortious interference against the Times.
Okay, so tell us a little bit about maybe really quickly give us just kind of what the new case is about. And then I think where we want to take this is to start to talk a little bit about some of the defenses that have been raised in the case, and in particular, what is known as the Anti-SLAPP Statute. Let's maybe start there, but maybe give us a nutshell of what sort of this second lawsuit is about.
Right. So this case was filed by the president himself. You may recall his brother passed away actually just a few months after that book case was filed. Right. So I believe he passed away in August 2020. So Robert Trump was the plaintiff in the book case. Now we have a case that's filed by the president, the former president himself, right? I believe it was September or October of this past year. And again, they try to file it in Dutchess County where the book case was litigated. I'm not exactly sure why, to be honest, why they filed there, because the judge ended up denying their preliminary injunction motion and agreeing with us that the contract did not apply, right? So, but they filed in Dutchess County. We get it transferred down here to New York County, which is Manhattan. And in that case, they argue breach of contract against Mary. And then there's some, unjust enrichment, which is basically duplicative of the contract claim, implied covenant. But then they also argue tortious interference with contract against the Times and the reporters that wrote the article, which is Sue Craig, Russ Bootner, and David Barstow, right? So it's against the three reporters in the Times, and they argue tortious interference and negligent supervision against the Times. And I think there's also an unjust enrichment claim against the Times. So the theory of the case is that by accepting documents and information from Mary that the president claims were covered by this settlement agreement, the confidentiality clause in this settlement agreement, that the Times tortiously interfered with Mary's contract with the president, right? And that Mary breached her obligations under this contract. So that's the theory of the case, right? But we are 2 years post-publication, right? The book's been put out, almost 2 years ago now. the Times tax story was in October 2018. So that's three plus years ago, right? So there's no element of prior restraint, no attempt to restrain or get any kind of injunctive relief. But they want disgorgement of Mary's profits from the book. And they want, he asked for $100 million in damages, right? And the Times in their brief dug up a bunch of examples where the president in other lawsuits had asked for $100 million in damages. That's just the number he likes, right? So it explicitly purports not to be a defamation case. It just says this is a breach of contract case, right? And one reason for that is that New York's anti-SLAPP law was recently amended to look a lot more like the California regime, right? So for those of you who don't know what anti-SLAPP laws are, SLAPP is an acronym that stands for a strategic lawsuit against public participation. And anti-SLAPP laws are designed to basically deter retaliatory litigation that is intended to shut down participation in the public dialogue, intended to shut down journalism, intended to shut down petitioning of the government, intended to shut down really any First Amendment protected activity, right? So lots of states have these anti-SLAPP regimes. New York's previously, up until pretty recently, was very limited. It was limited to cases where you actually were like applying for a zoning permit, like trying to get a permit from the government. So it was never used. But recently the state enacted a new anti-SLAPP regime that is much more robust, and it provides for fee shifting, as a lot of these statutes do. So if you move to dismiss, or it could be a motion for summary judgment under the anti-SLAPP law, and you win, you can get automatic fee shifting where your attorney's fees are covered. And this is really important for journalists and media outlets because litigation is expensive, and you can do a lot just by suing people to deter conduct, even if your suit is meritless, right? And the ironic thing, too, is that Donald Trump is mentioned in the legislative history as a reason for the expansion of the anti-SLAPP regime. And they literally are like, we are trying to stop people like Donald Trump from engaging in retaliatory litigation.
So is New York's anti-SLAPP statute now sort of consistent with what the law is in most places, or does this really vary state by state?
It varies state by state, but there are definitely consistencies, right? And I think about 30 states now have anti-SLAPP regimes. Some are more robust than others. California's is very robust and frequently litigated. DC has a robust anti-SLAPP statute. So a lot of states have them now. I do think that actually, in some ways, they may be the new battleground because, as we may talk about later, there has been this sort of recent round of criticism of New York Times v. Sullivan. But in fact, a lot of these anti-SLAPP regimes, they impose an actual malice requirement. And so you no longer, if the anti-SLAPP law applies, you don't even need Sullivan, right? And that's what we see going on in the Palin case, for example.
Right. Okay. So where do things stand now in the Trump versus Trump case?
Well, we have fully briefed motions to dismiss. This is in New York Supreme Court here in Manhattan. I would be surprised if the court did not schedule oral argument, but doesn't have to, right? Could grant it on the papers or deny it on the papers. And so that motion will be decided presumably sometime this year, hopefully.
Okay, great. And so the issue that is posed by those motions goes to the question of whether New York's anti-SLAPP statute applies to the facts of this particular case?
Yeah, so Trump has advanced the argument, the former president, as we like to call him in our papers, because Mary is also a Trump, of course.
He is the former president. I mean, that is factually true.
But the former president has argued that it doesn't apply at all because it's a contract case. But that's generally not how anti-SLAPP statutes work. And in fact, the New York one says that it applies. When you look at application of an anti-SLAPP statute, you're looking at the underlying conduct, not the legal claims asserted, right? So because the conduct that is alleged to constitute the breach here consists of providing information to reporters, those reporters reporting, putting out a book, these are all activities that are clearly protected by the Anti-SLAPP statute, even if there's some contract that they want to say is relevant, right? So, but his primary argument is that because this is a contract case, the anti-SLAPP regime doesn't apply at all.
And the anti-SLAPP statute, as I understand it, it's not absolute immunity, right? You still have to show something about the merits of the case, because let's say a plaintiff sues for breach of contract or for defamation, and they're right. I mean, their contract has been breached or they have actually been defamed. How does the anti-SLAPP statute apply under that set of circumstances?
Well, so what the anti-SLAPP statute in New York does, and what a lot of them do, is it imposes heightened burdens on the plaintiff. So in New York, in order to get past the anti-SLAPP statute, you have to show that your claims have a substantial basis in fact and law. And so that's why I mentioned earlier that these motions can sometimes be summary judgment motions, because if you choose to introduce material outside the pleadings to show, for example, let's say you're sued for defamation and you want to show that the allegedly defamatory statement is true, you might want to introduce something that's outside the complaint to do that, right? And you can do that under the SLAPP statute. And as you know, in normal litigation, you can't do that at the motion to dismiss stage. So you can do that under the anti-SLAPP statute, and it could become a motion for summary judgment. So it allows you to introduce material outside the pleadings, but it imposes a heightened burden on the plaintiff to show that his claims have a substantial basis in fact and law.
And the defendant gets to assert that before there's been discovery.
Correct.
Yeah. So it's sort of intended to cut the case off early, as opposed to waiting to the end when you would normally sort of hash out that issue by way of a summary judgment motion.
Exactly. Yeah.
Yeah. So kind of, I guess maybe the way to think about it, it sort of moves the summary judgment motion up to the front.
That's right.
A little bit. Yeah. I mean, as somebody who normally represents plaintiffs, I don't particularly like that, but I get it.
Yeah. And I mean, look, anti-SLAPP motions are not impossible to overcome.
Right.
But you need to have a real case, right? You need to have a claim that can withstand scrutiny. And okay, I mean, you also know, though, Jonathan, even when you don't have anti-SLAPP, there's so much motion practice, dispositive motion practice in defamation cases, because it is a very legally bound field. What can constitute a defamatory statement? So there's a lot of matter of law defenses in defamation cases. This is not defamation as a matter of law. This is a statement of opinion, so it's not capable of constituting a defamatory statement. So you always have a lot of defenses at the motion to dismiss stage in a defamation case. And the anti-SLAPP only reinforces that by imposing heightened burdens and by imposing the fee shifting, right? So, right. But you do always have strong threshold defenses in defamation cases.
Okay. And maybe that's a good transition point to start to talk a little bit about that. So one of those defenses is constitutional in nature. So maybe just give us, from your perspective as somebody who represents media entities, what is the nature of the constitutional protection that the press gets?
Well, a lot of it comes out of New York Times versus Sullivan, right? So the First Amendment, I mean, there's different theories about how to think about what the First Amendment protects, because the First Amendment is 30 words or something like that. It doesn't spell everything out, right? But the First Amendment over time has been construed to protect both the freedom of the press to put out the news, but also to gather the news, right? And it has also been construed to protect, to give them a little bit of latitude, right? And so that's what New York Times versus Sullivan does, is that it requires public figures to show, if they're going to assert a defamation claim, it requires them to show that the defamatory statements are made with actual malice, right? Which requires them to show that the statement was made with either knowledge of its falsity or reckless disregard for its truth or falsity, right? And also to show that there was a defamatory intent. So an intent to defame, knowledge that it would defame, or reckless disregard, right, for its defamatory nature. So again, there's a ton of case law around what this means, and it turns out to be a very high burden to overcome. And this is why it's come under criticism, because some people would say, well, it's gone too far. It provides too much protection because you can hide behind the standard and intentionally put out false information as long as you kind of cover your tracks. I actually think it's a great standard, and I fully embrace it. But, that's what critics would say, right? That it provides too much protection.
So for the benefit of our listeners, let's play a little devil's advocate. I'll play the part of the person who thinks you're wrong, and you can kind of tell me what you would argue on behalf of a client if you had a media client, let's say, who was being sued for defamation. All right. So, I mean, maybe we could start by just giving this a little bit of historical context and talking about where New York Times versus Sullivan came from, because I think this is actually relevant to a lot of the discussions that are happening now. So New York Times versus Sullivan was decided by the Supreme Court in 1964, right in the middle of the civil rights movement that was happening in the South. And what the case involved was a advertisement that had been purchased and run in the New York Times by a group of Black pastors in the South who were trying to draw attention to their movement that was being led by Dr. Martin Luther King Jr. at the time, and also to raise money for that movement, and to raise money for the legal defense of Dr. King, who was being subjected to, what a lot of people thought was sort of a trumped up criminal case against him for perjury in Alabama. So they run this ad, and the New York Times accepts the ad and runs it. And in the ad, they make a number of statements about things that the police force of Montgomery, Alabama, have done. And then a government official in Montgomery, Alabama, who's sort of a city commissioner who has some oversight over the police, but is not a policeman himself, brings a libel case against both the Black pastors who paid for the ad and against the New York Times, which published the ad, claiming that the ad itself was defamatory in various ways because it said things about what the police in Montgomery County, Alabama had done that they hadn't actually done. Now, that's a gross oversimplification of what the case was about. But that was the context. It was a very political case at the time, and it was really tied up in the civil rights movement at the time. The defamation case was brought in state court in Alabama, and the plaintiff was awarded $500,000 in damages against the pastors in the New York Times. This case goes up to the Supreme Court, and in an opinion written by Justice Brennan, the court, for the first time, this is in 1964, so the First Amendment's been around for, coming up on almost 200 years at that point, 170 years. But for the first time, the Supreme Court says, no, you cannot sue a public official for defamation unless you are, or you can't be liable for defamation against a public official unless you act with actual malice. In other words, that you're intending to defame them, something close to that. And so that's the context of that case. And then in subsequent cases, the Supreme Court sort of expanded the scope of that protection to include people that were not public officials, in other words, not government officials, but people that the Supreme Court calls public figures, people that are of newsworthy interest, you might say, even if they're not acting on behalf of the government. And there's been a lot of, I guess you could say, controversy about what exactly that means and whether or not that makes sense. But that is sort of the current state of the law. So if you're either a public official or a quote unquote public figure, you get this extra burden if you are suing for libel or defamation. All right. So with all of that by way of background, let's turn to kind of a little bit of what the current controversy is around New York Times versus Sullivan. And I think part of this is that in recent years, a couple of Supreme Court justices have gone on the record as saying that they think that the Sullivan case was wrongly decided. And maybe you can just say a little bit about that. Who are those justices, and kind of in what context have those statements been made?
Gorsuch, was it a case, Jonathan, or was it just a stray remark?
I think it was the place where it's been most clearly articulated, both by Gorsuch and by Justice Thomas, was in a dissent from a denial of certiorari.
Oh, so it was both of them.
Yeah, so they both wrote opinions, and this was just last year, in a case where a defamation claim was brought against the author of a book, and the book alleged that the plaintiff in the case was a member of the Albanian mafia.
Right.
And the plaintiff claimed that, in fact, he was not a member of the Albanian mafia. Now, let's just take it as a given that if you accuse somebody of being a member of the mafia and they're not, that is defamation. It's like what lawyers would call it's libel
defamation
per se.
Per se, yeah.
Yeah. So there wasn't any question that it was defamatory. But this actual malice defense was raised, and it was on that basis that it went up to the Supreme Court. And the petition for certiorari was denied. In other words, the Supreme Court's not going to hear the case on the merits. But as sometimes happens, sometimes justices will write little short opinions saying, hey, we should have granted cert. And that's what happened here. And in those opinions, Thomas and Gorsuch both strongly intimated that they thought that it was wrong. So let me just kind of tell you a little bit of what they say in those opinions. And maybe
I read the Justice Thomas. I don't know why I don't remember Justice Gorsuch actually writing on it.
Yeah, there were two opinions in the denial of cert. So let me kind of just bounce a couple of things off you and see what you would say to this. So the first criticism of New York Times versus Sullivan, and this really goes to the sort of expansion from public officials to public figures. Now, I think the argument of applying it to public officials is actually much stronger, and it's actually articulated by Justice Brennan in the Sullivan opinion, because he basically says, look, if you don't create this extra defense to lawsuits by public officials can basically use libel lawsuits to get around just the most basic First Amendment protection, which is the protection of criticism of the government.
Yeah.
Right. So somebody publishes some criticism of a government agency, and the head of that agency says, you're libeling me. Right. And they say you really shouldn't be able to do that. But when you expand it beyond public officials to public figures, people who are not acting on behalf of the government, the justification doesn't really make as much sense. So what would you say to that? Why should somebody who is not a government official get this extra defense or be subject to this extra burden of proof in a defamation case?
I really think because litigation has such a chilling effect, and you can be a public figure who has just as much or more power than any government official. I mean, what if you're the head of Amazon or Apple or, any number of large corporations? You have a lot of power if you are that person. And I think, if you're going to criticize the degree to which it's become something of a meaningless standard, right? Being a public figure. What does it mean, right? And there's a lot of litigation around that in defamation cases because, of course, defendants want the protection of this actual malice standard. And I think you could validly say that we've gone too far in what it means to be a public figure. But I think that, if the idea is that we want to encourage robust debate about issues of public concern, then it makes sense to extend that standard beyond simply government officials, right?
Okay, so let me push back on that a little bit. This, I think, what you just articulated is really sort of the key argument in favor of these protections, which is that even if it is bad to make defamatory statements, we have to allow a certain amount of defamation in order to protect non-defamatory statements, right? But why is that true? Why can't it just be that if you speak the truth, you're fine, And if you defame somebody, you're not fined. Why does this tort need this extra layer of protection where even tortious conduct gets excused?
I think that there's a number of reasons why that needs to be the case. I think one is that freedom of speech is not just about the ability to speak, but the ability to speak in certain ways, right? And I think colorful, hyperbolic speech, angry speech needs to be protected, right? And oftentimes that can involve speech that might be considered defamatory, right? But it may be rhetorical or being used for effect, right? So I think that's one reason is if you want to allow robust debate and robust dialogue about issues of public concern, then the protections of defamation need to extend to those issues, and a proxy for that is allowing it to extend to so-called public figures, not just public officials, right? So I think part of it is that there needs to be some penumbra around the kind of speech that we're talking about in terms of protecting, immunizing speech from accusations of defamation. I think another reason is, again, the chilling effect of litigation, even if it's meritless, even if you win it at the end of the day, it has a tremendous chilling effect. So you want to deter bringing the litigation and have it be reserved for those cases where it's very much warranted and where there's actual damages. And you see this also in defamation case law, right? There's requirements of special damages. You need to have actual damages from the defamation. It can't just be inconsequential, so it can't just be the way our kids insult us sometimes, right? There has to be damage from it, financial damage. And so I think you want to deter defamation lawsuits just based on everyday speech. There has to be a real reason for the suit. And because I think lawsuits have a real chilling effect. I know that they do. I mean, especially having represented individual reporters, it's incredibly taxing for them to be sued. And even if they win, which usually they do because of these protections, it's very taxing. And so I think you have to deter those kinds of cases.
Okay. So I think what the Thomases and Gorsuches of the world would say in response to what you just said is that argument assumes a media landscape that might have been true in 1964, but is no longer true today, which is that back in the 1960s, the media landscape really did mean companies that were publishing newspapers or companies that were running radio or TV stations. That was the media that New York Times versus Sullivan was intended to protect. They were institutional media. Now we live in a world with the internet where the costs of production have gone way down. Anybody can be a journalist. Anybody can go on the internet and say anything they want, publish a blog, publish something that looks like a newspaper. And there's no longer sort of a small kind of, sort of trusted media that we need to protect. And when you create these legal protections, you can't have them only apply to the New York Times and the Washington Post. They have to apply very generally. So this sort of concern about chilling effects, while that may be true if you're talking about serious journalists working at the New York Times, why would you have that concern around, some, I'll say, highly politically motivated blogger who is not really that concerned about being super careful and about their reputation and so forth? They're just going to go on the web and publish defamation sort of willy-nilly to make whatever point they're going to make. And in that media landscape, why would we have this continued concern about chilling effect? I mean, there's so much speech going on. Even if we chill 10% of it, we'd still have way more than we need.
Well, listen, I think that all of that cuts both ways. I mean, first of all, if you're going to change the standard, how do you draw lines between those you change it for and those that you don't, right? Do you want the government, you want judges deciding who's a real media company or not? I mean, some media companies may start out as a guy in a room or a woman in a room, and then they turn into big companies. So I don't think we want the government, including the courts, to be deciding who merits First Amendment protection, right? and who doesn't. What's the real press? What's not the real press? So there's that. I also think that even if, I think you're right, there is this sort of proliferation of speech, and now because of the internet, there's a proliferation of speech that's accessible to everybody and that effectively has worldwide distribution for whatever that's worth, right? And so, you do have an issue where people do say all manner of things, and there's maybe not a whole lot of legal recourse for people who might be damaged by that. On the other hand, there's a natural, I think these cases are still mostly being used to deter speech by establishment media, right? Because it matters more if the New York Times says something about you, if CNN says something about you, if NBC says something about you, than some blogger, right? That may be becoming less and less true, right? But I do think that, the Palin case is a good example. It matters a lot more if the New York Times says it. It matters more if Fox News says it. And so I do think that there is, even though we have a lot of speech and a lot of it has worldwide distribution, not all of it matters in the same way, right? So I don't see how you institute a system where you protect the established media sources and you don't protect the little guys. I just don't see how you draw that line. And I don't think it's something that we want the government doing.
All right. So I'll make the next argument, which is that we've just got the balance wrong. That even if there is an interest to be protected, a press freedom interest to be protected, we are undervaluing the harm that libel can cause, true libel. That damage to reputation, particularly when it's coming from a quote unquote trusted media source, can be really crushing on people. And I can say I've represent, my firm has represented folks in this situation, and I've talked to other folks who have wanted to bring defamation cases where their lives have really been turned upside down. And this is we're not talking here about sort of high profile political figures. We're often talking about people who get written about in, say, a news piece, who until that moment, right, we're just going on about their lives and we're not like seeking fame and fortune. And all of a sudden something is written about them that just upends their lives. And it's very hard to rebut that in the public record. It's very hard to scrub that libel out of the record the way the internet works. So even if you have retractions and corrections, it doesn't really do the trick. And why should those people not have some redress for that harm?
Well, I think there's a few things, right? Which is that they do have some redress. In particular, if they're not public figures, ordinary standards are going to apply, right? So they're not going to be subject to the actual malice standard. Second of all, I mean, this is a debate under the First Amendment that goes back, to the early days, which is what is the cure for bad speech? And, I think a lot of people would say the cure for bad speech is more speech, right? And we help companies do that all the time, counteract narratives that are incorrect. And those companies don't have a direct legal remedy normally for that speech. And really, no company necessarily wants to go into court and say they've been harmed by defamatory speech. So the way to counteract misinformation is to put correct information out there. So that's what I would say to that is the remedy there is more speech. The remedy is not punishing the original speech that may have been incorrect, right?
Okay.
But when the press does get something wrong, they will retract it as well, is what I would say. If there are factual inaccuracies, they are required to and will fix them. So, I mean, that's the other thing, right? They will, especially the establishment media, they will fix stuff.
Yes, that's true. And that did happen in the Palin case, which we'll talk about in just a minute. All right, I'll give you one more argument, and then maybe we should turn to talk briefly about the Palin case and what's going on in that case, just because it's so in the news right now. So the last argument that I'll float out there, and this is really the one that is probably on the minds of Justice Thomas and Justice Gorsuch, which is sort of reflective of their constitutional philosophy. What they would say is, look, until 1964, this right of the press, if you will, to have this actual malice standard didn't exist. It's nowhere in the text of the First Amendment. It was essentially made up by Justice Brennan for the first time in 1964. And this is just judicial legislating. If this is such a good idea as a matter of policy, it should be left to the legislative branch. And as we've seen, for example, in New York, as you say, you have a good anti-SLAPP statute that accomplishes much of what the actual malice standard was intended to accomplish anyhow. And so why should this be a matter of constitutional law as opposed to legislative debate?
Well, I mean, if we're going to take that approach to the First Amendment, really any of our constitutional amendments, it's hard to say what protections any of them would actually provide, right? Because they're all extremely brief and cryptic. And if there's no judicial gloss on them, I don't know what any of them mean. I mean, literally. So I think that is, I don't think it's a tenable approach to constitutional interpretation. I just don't. And, I don't know how you interpret and apply the First Amendment in a way that's meaningful without developing common law around it, without being a judge.
Yeah, on that issue, I totally agree with you. And but this is like a big debate that goes beyond just libel and defamation law. It's at the center of the debate about Roe v. Wade as well, and
Second Amendment as well.
Yeah, the Second Amendment interpretation. So this is just part of that bigger judicial debate that happens in the Supreme Court between different sort of philosophies of judicial interpretation.
Although I think it's somewhat disingenuous too. I just, are these the same judges that would give it a broad, expansive interpretation with respect to their, religious freedom? I mean, how are they going to say that that's not putting a gloss on it? The First Amendment, again, I mean, I'll read it. It's very cryptic.
It's the first one, so it's right at the top, Annie.
I know. I'm just, I'm using Google. I should have my paper copy, This is the so-called freedom of speech and press clauses, right? Well, I'll just read it from the beginning. It's so short. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances, right? I mean, I don't know what that means without judicial gloss, because the First Amendment has been interpreted to not just to stop Congress from making laws about religion, but laws that have an incidental effect on religious institutions, right? And so I don't know how that's not judicial gloss. It doesn't say that. It doesn't say you can't pass a law that affects a religious institution. It just says you shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, right?
Yeah. Well, I mean, look, that's why constitutional law is so interesting. It's one of the most fun classes you take in law school. And whenever you get constitutional issues in a case, they're always the most interesting for exactly this reason. It always just thrusts you into these big debates about judicial philosophy and how do you interpret this document hundreds of years later and what is the right way to do that. And so the actual malice standard in New York v. Sullivan is just one example of that. So you're absolutely right.
Well, and I think that maybe the reluctance is the canonization of tests and, like finding words there that are not actually there and canonizing them into tests that are applied over and over again. And maybe that's the objection, is like, we have this actual malice standard. The Constitution doesn't say anything about actual malice. It doesn't say anything about public figures. It doesn't say any of that. So, I mean, I understand the nature of the criticism, but I honestly, it's hard for me to understand how there is a valid way of interpreting the Bill of Rights that doesn't go beyond their text. I mean, some people would say you have to understand it as it was understood at the time. I don't even know what that means, right? You've got a room full of guys signing this document. what did it mean? I mean, do we ask just the one guy? Do we ask John Adams? Like, who do we ask?
We ask Hamilton because he's down there on Broadway. Right?
Yes, exactly.
Just
and he wrote what 80% of the Federalist Papers.
Right, just a few blocks from your office. Just head over there after the show. Wait by the door behind the theater, and when he comes out, ask him what he thinks. So let's talk a little bit about the Palin versus New York Times case. And as we've been talking, this is breaking news. We just checked the internet, and it looks like the jury has come back with a verdict in favor of the New York Times, the defendant in that defamation case. Still trying to sort out exactly what happened. But Annie, why don't you kind of tell our listeners a little bit, what is that case about?
Well, so this is a case brought by Sarah Palin against the New York Times over an editorial. So this editorial was written in the aftermath of that shooting in Virginia where Representative Steve Scalise was shot. Remember that it happened at a baseball field. So this is 2017, right? And the New York Times publishes an editorial called America's Lethal Politics. And the sort of gist of the editorial was that, there's been a lot of political violence. We had the Gabby Gifford shooting, a lot of other political violence. Is there some link, to our political rhetoric? And shouldn't we be a little bit more careful as a country about the way we talk about politics, because we don't want to be inciting violence against public officials, right? So that's the gist of the editorial. And the language that Sarah Palin complained about basically implied a link between the Gifford shooting and material that had been put out by her PAC, her Political Action Committee, which put targets like gun site targets over certain congressional districts. So the editorial did get something factual wrong in that it said that the targets were over the candidates themselves, which was not the case. It was actually over their districts, right? And implied that there was a link between the Gifford shooting and the material put out by Sarah Palin's PAC, right? So those were the allegedly defamatory statements that she sued over. So this case has a little bit of an interesting history because the Times from the outset relied on the actual malice standard. They quickly had, by the way, they had quickly corrected the article online, but it did come out in the print edition and in early versions online. They quickly corrected it to remove, what was, if not explicitly stated, an implication that there was a connection between these materials put out by Palin's PAC and the Gifford shooting. So early on, the Times relies on the actual malice standard. Rakoff ordered some kind of early mini trial on this. And the Second Circuit said, no, you can't do it that way. It gets sent back down. So the case kind of lasts for a long time. And I think a lot of us were surprised when it actually got to a jury trial, because the Times then did seek summary judgment on the actual malice issue before trial. And Judge Rakoff denied it. It goes to a jury, right? So it goes to a jury. The Times, they asked permission to, and in fact read the entire editorial to the jury. And James Bennett, the editorial page editor at the time, testified at length. He took responsibility for the statements that had been retracted, that were considered, that Sarah Palin was alleging were defamatory. But he also went into a lot of detail about the process that led to the drafting of the article, those specific statements, which involved a lot of research, a lot of gathering articles, looking at what had previously been published. So the Times had put in time and work into this. And even if they got something a little bit wrong, or the implications were not exactly what they intended them to be, it was clear that they had gone through a process, right? This wasn't, intentional. It didn't appear to be intentional, did not appear to be, an intentional misstatement. And so it goes to the jury. The jury goes out for deliberation. The Times makes a routine motion for judgment as a matter of law. And Judge Rakoff yesterday indicates that he's inclined to grant it. And this is while the jury is deliberating. And then we just found out just about an hour ago, the jury did return a verdict in favor of the Times.
Okay. So I think what that means is that the Times has won the case in two different ways. One by way of the jury just finding probably that the actual malice standard was not satisfied. I mean, we don't know exactly how the jury verdict was rendered yet. I mean, they might have actually been asked a question about, was there actually any libel? And they could have found for the Times on that basis as well. But either way, there's also been a legal ruling, or there will be a legal ruling from the judge that regardless of what the jury found, the Times should win because the actual malice standard protects them as a matter of law. And I think the working assumption of every lawyer that's been watching this case is that this is just the next round in what is going to be a long battle, that there will likely be an appeal. And that as part of that appeal, and I think this was already signaled by Palin's attorneys in the trial court, as part of that appeal, they're going to be making essentially a full frontal assault on the New York Times versus Sullivan standard in the hopes of eventually getting the case up to the Supreme Court and testing how it'll do in front of the current Supreme Court. So this will be a really interesting case to watch, and I'm sure lawyers like Annie who represent media entities will be watching this very, very carefully. And it should just be a really, really interesting case going forward, regardless of what the jury found.
Well, I will say, though, that I think that Palin's plans could be complicated by the fact that the New York Anti-SLAPP statute has been found to apply. Because, again, that statute adopts the actual malice standard for any claim that involves the truth or falsity of the statements, which includes defamation, right? Some claims, for example, the contract claim that's been asserted against Mary that relates to a non-disclosure agreement, the claims there have nothing to do with whether the statements are true or false. In her book, in the New York Times for coverage, in the materials she provided to the Times. But defamation, by definition, requires that the allegedly defamatory statements be false. And in that case, the New York Anti-SLAPP statute adopts the actual malice standard. So not only do you have that standard coming from New York Times v. Sullivan and applying to the case, but you also have an alternative state law basis for it. So listen, that doesn't mean the Supreme Court's not going to touch it, but normally they wouldn't actually touch a case that had an adequate state law basis. Right. But if there are more than two justices that really want to look at this issue, they may very well take up this opportunity, even if there's an adequate state law basis for the application of the actual malice standard.
Yeah, no, that's a really interesting point. And just to kind of give this a little bit of context, I think what Annie is saying here is that because there is a basis under New York law for the New York Times to win, that even if you change the constitutional standard, even if you got rid of New York Times v. Sullivan, the New York Times would still end up as the winner in the case. And because of that, the Supreme Court might not see it as a good test case for New York Times versus Sullivan. And that is definitely true. And there isn't anything in the Constitution that prohibits a state from doing whatever it wants to its own libel laws, right? So the underlying issue here is that libel law itself is a matter of state law, not federal law. And so a state can just eliminate libel law entirely, and there's nothing in the Constitution that would stop them from doing that. So there's no constitutional limit on the right of individual states to immunize defendants from libel suits, right?
Correct. And I think that, unless there's some other substantive right involved, but it's hard to think of a scenario where that would be the case.
Right.
But I think that because of that, it's not a great vehicle for testing New York Times v. Sullivan. But that said, if there's enough justices that are interested in that issue, you may see them touch it anyway, right? Even if it's only to issue what might amount to sort of an advisory opinion.
Absolutely. And New York Times versus Sullivan itself had two different bases for its decision. Justice Brennan, in the majority opinion, said at the end of the opinion said that the statements at issue in the case were not of and concerning the plaintiff, which is another basis for finding in favor of a defendant in a libel case. In other words, he was saying that this ad that was run by the black pastors in the New York Times, it didn't even mention this guy who brought the case. And there wasn't any reasonable interpretation of it that would lead you to think it was about him. And on that basis alone, the case would have been thrown out anyhow. That didn't stop him from adopting the actual malice standard. So
yeah, and that's actually an issue in the Palin case too, because the statements are technically made about her PAC, not about her.
Right.
So I know the New York Times, and that's in the jury instructions, that the statements need to be about her or need to be understood to pertain to her, right? And so the New York Times did challenge that in this case as well.
Yeah. Yeah. So anyhow, we will see. I'm sure the saga is not over, and there will be more to come in the Palin versus New York Times case. Well, thank you, Annie, for kind of walking us through all of that very complicated law, the Anti-SLAPP statute, and for putting up with my challenges to the actual malice standard. But I hope people found that discussion interesting and illuminating a little bit about sort of what that whole issue is around libel law in the press. So let's now turn to something different and a little more personal to our guest. So this is not the first podcast that Annie Champion has appeared on, and certainly not the best or the most professional. So Annie is also sort of the featured character in a podcast called Bonaparte, which I listened to. I think it's a 10-part series, and it's a really fascinating kind of true crime story. And Annie, maybe just if you can just kind of summarize in a minute, like what is this podcast about, and how did you get involved in it?
Well, it's about the murder of a friend of mine 25 years ago. Her name was Laura Van Wyhe. She was found almost lifeless by the side of the road in northern Missouri, a couple of hours from where I grew up. And she died a few hours later in a hospital in Quincy, Illinois. And her case is unsolved. It was deemed a suspicious death and it has been investigated as a homicide. And at the time it happened, I was primarily just grieving the loss of a friend, and I was not a lawyer yet. It was right when I was graduating from college. And so I wasn't really thinking about solving the case or anything like that. I thought, that's somebody else's job and not really something I really spent any time thinking about. But a few years ago, but it always bothered me, by the way. And a few years ago, there was a deputy sheriff in Iowa that was about to retire, and he just wanted to shake the trees a little bit to see if he could get any movement, because it had always bothered him that it hadn't been solved. And the Iowa authorities did not have jurisdiction over the investigation. It was being run by the Missouri Highway Patrol, but they had been involved because the night that she was killed, she had been in Iowa and had been transported across state lines to Missouri. So Iowa authorities had been involved in the investigation, and potentially events related to her death might have taken place in Iowa. We really don't know. So he had started reaching out to people, who knew Laura or who he thought might know something. And he was primarily working through Laura's mother, Leanne Thomas, who I've stayed in touch with all these years because I'm still friends with Laura's sister as well. So at that time I was like, well, I'm a lawyer now. Maybe I should just look at the file and shake some trees and see if I can get some movement on it. And I always thought it would be solved, by the way, but it never was. So here we are 20 some years later. So I got a version of the file that her mother had, which was an old version. It only covered about the first 6 months of the investigation or so. And I read that and I was like, wow, this case really should have been solved. It's kind of like a game of Clue. She's at a party that night with a defined number of people. It seems almost certain that at least one of those people is involved in what happened to her later that night, right? So I began to feel very strongly that this case should have been solved and that it was still solvable. So I started doing some things. First, I tried to get the FBI involved. That did not work, although I'm still hopeful maybe they will get involved. And then I was just talking to the local police and trying to see if I could get any movement on the case, and working with her mother, with Leanne. And we did, in fact, get some movement. I mean, they did do, a little bit more investigation. And, but then it went cold again. And I was like, what can I do here? And I thought, well, maybe I could get some media attention for it. Right. And I was really just in the preliminary stages of thinking about how I might do that. And I happened to be in the backyard of a friend of mine, former Gibson Dunn attorney, Mark Dorr, here in New York City. I'm in his backyard, and we're having drinks with another former Gibson Dunn attorney, Jason Stavers, who has since quit practicing law and has gone to NYU to get a journalism degree. And he wants to do long form nonfiction, right? So magazine pieces, things of that nature, and maybe also podcasts, right? So I literally just said, oh, he's talking about his program and what he's studying and what he's learning. And I said, you should do a podcast about my friend. And I told him the story. And, but it was not the kind of thing that I thought would actually result in anything, right? I'm just chatting and, but he ran with it. And he went out and found a producer, got funding, the whole thing. And I really give him a ton of credit. I mean, he did a lot of legwork, and I think the podcast is beautifully made. And, just as importantly for me, first of all, I think it preserves, a lot of people's memories of Laura, which has been very gratifying for those of us that knew her. Because something happens when someone dies so young, right? There's this kind of scattering. So we're all over the place. And the podcast kind of reconnected the people that knew her and loved her in a great way. But it also really has generated a lot of movement on the case. There's a limited amount I can say about that, but I do think it's been extremely productive. It has gotten people in the area to talk about the case in a way that they never have. A lot of people who were around when this happened didn't even know about it, had never heard about it. And it's kind of amazing the stuff that I've learned since the podcast came out. So it's been a pretty amazing experience.
Yeah, and like I said, it was really interesting to listen to, and I found it very moving as well. I mean, there is certainly like the through line of the podcast is about Laura's death and the investigation into it, but there's so much. It's very layered. It's also a little bit about you and your life. It's about sort of the lives of people who stayed versus left. I mean, there's this very touching moment in the podcast, I think, where you've gone back to Iowa and there's sort of a gathering of your old high school crowd, I guess.
Yeah.
Laura's old friends. You get together for dinner one night and start to just kind of trade stories about her. And that was just a really just sort of emotionally touching moment about the people that were sort of left behind. And so I think that the story really works on a lot of different levels. I mean, I think you probably went into it with a very kind of instrumental goal of let's get this crime solved. But the podcast operates, I think, on a lot of different levels.
Yeah, I agree. And I think that, one thing that was hard or scary about even thinking about approaching the media about a person that you care about and who's no longer here to speak for herself is not wanting them to get it wrong, or doing something that I don't think serves her memory or is unfair to her or her family or other people that cared about her. And I think that first of all, I trusted Jason. I knew him. We had worked very closely together on the Chevron case. He was a great attorney, actually. He definitely would be a partner here if he had stuck with the practice of law. But he's a wonderful writer and just has great insight into humans. And I think, he actually saw a lot in the material that I wouldn't have even necessarily have seen because I'm too close to it, So having lived through it, it's a different perspective than coming in as a writer and looking at it. And I think he did a beautiful job and, really put out a great portrait of Laura, of the time, of, just everything. He did an amazing job.
Yeah, I agree. And you've also got a website out there that's sort of devoted to this case, right? Do you want to plug that?
Yeah. So, again, trying to think about how I could get the investigation to move forward, around the same time that I was thinking, I need to get some media attention, I had decided to do a reward for information leading to an arrest and conviction of people involved. So I had been talking about that with her mom, and we had decided to move forward with that. And so as part of that, I was like, well, I need a publicity strategy because people need to know about the reward, right? If it's going to do any good. I had the conversation with Jason. I already had the reward in mind, but we hadn't announced anything yet or anything like that, right? So we ended up announcing the reward probably 6 months or so before the podcast began. And we did that with a website and a Facebook page. We got some coverage in the Des Moines Register and USA Today. And that kind of seeded the ground, right? Where especially people in the area knew about the case, knew about the reward, were being reminded of things. And then Jason starts making the podcast around that same time as well. So the reward now, we have increased it because a lot of people were like, I want to contribute. So basically I've taken pledges from people. We'll be announcing the amount that the reward is up to actually pretty soon here. And more importantly than that, it's just been remarkable the number of people I've heard from in the area, people who knew someone, people who heard something, people who saw something. I mean, it's really been amazing. I really had no idea how far and wide that it would reach. But yeah, so the website is, I think, championforlauravanwyhe.com. There's a Facebook page. The podcast is Bonaparte. But yeah, it's really been incredible. And, maybe we'll solve it. Maybe we won't. But I think it's absolutely been worth the effort to try to do it. At least I won't feel like I didn't do what I could,
And what was the experience for you of actually making the podcast?
It was interesting. I mean, I think, it's so long ago, and I was such a, I don't want to say I was a different person because I wasn't, but I was at a very different stage of my life when all this happened. And so kind of, putting myself back in the shoes of that younger person, going back to those places, it's just, it was intense, it was really intense. But the great part too, again, is touching base with all those folks that knew Laura. That's been amazing. And so it was definitely worth it, but it was definitely emotionally exhausting. I feel like I'm actually only just recovering because we finished recording it in December. The last episode was released at the end of December. And then I was just like, I need a month off. Like, I just need to just sleep and think about something else. But now we're getting ready to gear up with the social media again and put out some more information and keep collecting tips from the public, because that really has been the most productive part.
Yeah. I mean, how did you find time to do all that while keeping up with your law practice? And I know you've got kids at home and just everything. It must have been a very just intense period of time.
Yeah, it was. But again, Jason really, he did the hard work,
Yeah. Well, we will put a link to the website. I think it's championforlaura.com in the show notes for this episode of the podcast. And again, the podcast itself is called Bonaparte with an E at the end. So Bonaparte. That's the name of the podcast, and it's a reference to one of the locations that's kind of important to the story. And yeah, it's very touching. It's very dramatic. There's some just really like tense moments where literally recordings of you sort of confronting people that are key players in the story, and it really had me really absorbed. And I listened to all 10 episodes, and it was really great.
Well, hopefully we'll get some bonus episodes. If there's a major break, I think we'll try to do some bonus episodes.
Yeah. Well, I absolutely wish you the best of luck with that. And I think with that, we've been going for quite a while. I should probably let you get back to the business of law. I know that your time is very valuable, and I just want to say thank you so much for sitting for this interview and for talking to us about these interesting legal issues, and also for talking to us about Laura Van Wyhe.
You are welcome, and thank you for having me. It's honestly great to just talk with you, Jonathan. I keep an eye on your career, and I love that you keep evolving and doing new things. It's awesome.
Yeah, likewise. Well, thanks again.
All right, take care.
Thank you for listening to this episode of the Garrulous Gavel. If you enjoyed it, please subscribe wherever you listen to podcasts. You can always find us at garrulousgavel.com. If you'd like to send feedback or suggest a guest, please contact us at our email address, garrulousgavel@gmail.com, or on Twitter at garrulousgavel. Our cover art was created by artist and illustrator extraordinaire Joan Tico. Our theme music was written and performed by scientist and saxophonist extraordinaire Robert Tico, and our producer is the inimitable K.O. Myers of Particulate Media. See you next episode.